All right. And well, they will.
For the world's leading dispute resolution institutions, including the ICJ, the European Court of Human Rights, and the International Center for Settlement of Investment Disputes. Prior to joining Foley, Yulia served as a law clerk at the European Court of Human Rights and as an international arbitration associate at a large international law firm in Washington, D.C., where her practice focused on investor, state, and commercial arbitration. Yulia received her JD from Yale Law and her BA from Boston College. Next, we have John Muse Fisher, who is a senior associate in international arbitration at Arnold and Porter from San Francisco. We're very excited to welcome John here today. John focuses on international arbitration, including commercial and investor state disputes. His practice includes representing sovereign states in high-stakes arbitrations, including the Republic of Korea in its multi-billion-dollar investor state dispute with Lone Star Funds Turkey, in its investor state arbitration against Pakistan that resulted in a nearly $800 million award, and the Philippines in an investor state arbitration involving Shell. John also brings significant experience in climate change issues, international service of process, and space law. John graduated from Berkeley Law with a certificate of specialization in international law. Next, we have Tom Walsh, who is a partner of international arbitration from Freshfields, who is joining us here today from New York. Tom has significant experience representing clients in investor state disputes, including serving as counsel to Glencore Finance and securing a landmark $254 million award against Bolivia under the Bolivia-UK Bilateral Investment Treaty. His practice includes advising multinational energy companies in complex commercial arbitrations and post-M&A disputes. Tom is particularly active in Freshfields' Latin America arbitration practice, representing foreign investors in treaty arbitrations throughout the region. Tom is also an alumni of Berkeley Law. We also have Tyler Jankauskas, who's joining us from New York. He's an associate with International Arbitration and Disputes Practice at Covington and Burling. Tyler advises clients across industries in complex international disputes. His arbitration practice includes representing private entities and states in commercial, investor state, and state-to-state proceedings under ICC, ICSID, UNCTRAL, and UNCLOS rules. Tyler has represented U.S. telecommunications companies in investment treaty arbitrations against Georgia and advised clients on public international law issues related to the Russia-Ukraine conflict. His experience with sovereign representation includes work on a law of the seas matter, building on Covington's expertise in maritime disputes. Tyler also maintains an active pro bono practice, recently litigating international treaty claims in a federal court. Tyler is joining us remotely and is also up there on the screen. And our last but not the least, last panelist is Katie Connolly, who is an associate in international arbitration at Norton Rose and Fulbright. Katie advises clients in complex international disputes. Her arbitration practice includes representing corporations and sovereigns in commercial and investor state proceedings under various arbitration rules. Katie has represented an energy company in a US $100 million NAFTA claim against Canada, a mining company in a $750 million award enforcement proceedings, and an international conglomerate in a US $350 million London Court of International Arbitration proceeding, resulting in favorable interim awards. She has also represented a maritime classification society in an American arbitration associate case, seeking a no liability declaration for euro 40 million in alleged damages. Katie serves as an assistant editor for Institute for Transnational Arbitration and Review and co-chairs the Young California Arbitration Association. And finally, our moderator, Professor Neil Popovich, who is the Frank C. Newman Lecturer at Berkeley Law. Professor Popovich is also a partner at Shepard Mullin, where he leads the firm's International Litigation and Arbitration team and ESG and Sustainability team. His practice spans international commercial arbitration, investment arbitration, and transnational litigation. Professor Popovich also teaches international environmental law and international litigation and arbitration at Berkeley Law and has published extensively on international law, human rights, and environmental issues. He is also a Berkeley Law alum. Please welcome me in joining all of these incredible panelists today.
I'll try this one. Everyone can hear me. Hi, welcome, everyone. Thank you so much for coming. This is a fantastic turnout on both sides, I would say. We have a great panel. And my approach when I decided that I wanted to do something involving transnational litigation, international arbitration, public international law, was to kind of look around the landscape and see who is doing this kind of stuff, where are they doing it, and how did they get there? And then try and chart a path. So hopefully that's what we're going to get a chance to think about today, hearing from all these people about what they do, how they got there, what kind of cases they work on, how their firm structures the international disputes practice. There's a lot of different ways to do it. How pro bono fits in, because that's an important thing for a lot of people who are drawn to this kind of work. What kind of skills you need. A lot of this has to do with not just what you like, but also what you're good at, what you can succeed at. It gives you satisfaction that you sometimes don't get if things are a struggle, but sometimes you get more satisfaction if they are a struggle, and you learn how to do them. We're also going to hear, I'm sure, some anecdotes, because people have interesting stories, and interesting cases are part of why we're drawn to this practice. And then figuring out, if you're trying to get into this kind of work, how you do it. What are the things all of these panelists have learned along the way to help them navigate their way into this kind of practice? What are the things you want to try and approach, try and gravitate towards? What are the things you want to avoid? There are lessons to be learned always in both directions, from your peers, from people who you look up to, figuring out what kinds of lawyers you think you want to be like, what kind of lawyers you think you don't want to be like, what kinds of lawyers have interesting practices that you would like to emulate. And then, of course, if there are some practical tips that these folks have, because they're all a lot closer to the job search process than I am at this point in their careers, although some closer than others, and where to look, how to look around. For many people, particularly in a traditional US law school environment, this is not the standard path. And also there are many people in this room who are not traditional law students, many LLM students or others who have some other legal training, some other path other than just coming straight through a US university and going to law school and being a summer associate at a law firm and then trying to get your offer to go there full time. So with that kind of context, let's start with one of our remote panelists. Yulia, take it away.
Thank you so much. It's really a pleasure to be here. Pleasure to be here virtually. It would have been nice to have been in person as well, but happy to take part in this panel, and thank you so much for the invitation to join you this evening. I think my task now is to tell you a little bit about my work, about Foley Hoag, where I work, and some of the facets of our practice, and how we sort of structure our firm's practice. So as you know, it's been mentioned, as you all know by now, I work for Foley Hoag. I've been with Foley for about 5 years now. Like maybe many of my peers and maybe others on this panel, I joined at a very strange time right before the pandemic. So I joined Foley in February 2020 and then had a very strange introduction to the firm and to the community, unfortunately, because we all went remote. But despite that, it's been an incredibly fulfilling 5 years. I love my job. I love talking about my job. And so it's always a pleasure to be part of these panels and sort of share my experiences working here. To kind of give you an overview of Foley's international litigation and arbitration practice. We have, at the moment, 5 offices. Foley has 5 offices, 4 in the United States and 1 in Paris. The ILAD department is spread across 4 of them: Boston, New York, Washington, D.C., and Paris. We work very much across offices. When we staff cases, we're not staffing a case to a specific city or a specific team. It's very much based on availability, on, yes, as we mentioned, the skills that are needed for a particular case, the attorneys, the level of attorneys, how much time they have. But yes, so we have 4 different offices. We work across all of them. Within the type of work that we do at Foley, I like to say that there's sort of a couple of different buckets of work. There is what I would consider maybe the more bread and butter of practicing international law in a private company and a big firm, which is, I would say, commercial arbitration, international investor state arbitration, and commercial arbitration. And so that's a large part of what we do. We also have a public international law practice, which is the state-to-state disputes, but also state advice and representation in a number of both contentious and advisory opinions. We have a smaller practice that's representing sovereign states within the domestic courts in the United States, and sometimes in our Paris and France and from our Paris office. And then we have a UN practice group, which I think is slightly separate, and although, cuts across some of all of these different buckets of work. And within the UN practice group, we offer a lot of advice on all matters to do with the UN, to various different states and their missions, both in New York, but more broadly. What makes our firm a little bit different, I think, though perhaps not necessarily unique anymore, although it may still be unique in that sense, is that we only represent sovereign states. So in all of the different buckets of work that we do, both in arbitration, in PIL work, in domestic work, we represent governments, states, and we do sometimes represent state-owned entities. And in commercial arbitration, we have also represented private companies. you know, for us, that's always been a very important and quite big part of our representation. We feel that the fact that we exclusively represent states gives us a very coherent approach to issues in international law. It allows us to have a very coherent strategy for approaching cases. There is obviously a lot of benefit to being able to see a case from both the perspective of a claimant and the respondent. But we find that having just the state representation is sort of strengthens our position in terms of offering our state clients a variety of different tools for their representation. How the caseload is split for each individual attorney is very different. Certain attorneys have a very good mix of all the different practices that I mentioned and the buckets I mentioned, a mix of arbitration, both commercial and investor state, PIL work, perhaps some representation of states in domestic courts, some work with our states in the human practice group. For others, it skews much more one way or another. From my personal experience, I say I've been fortunate because, you know, I always really loved public international law. I think a lot of students who are sitting in classrooms, you're learning about all these incredibly exciting cases and interstate cases. I worked, as someone mentioned at the beginning, at the ECHR as a law clerk. So when I came to Foley, I've had the good fortune of working on a lot of interstate cases. My work began representing the state of Qatar a few years ago at a time where there was a blockade against the state of Qatar by some of its neighboring states. And what this in practice meant was that Qatar had sort of isolated itself from a lot of its neighbors in the world. And so they brought a number of cases, very unique and interesting cases, to try to break through this blockade. And this was sort of my first foray into interstate disputes. We had cases before the Universal Postal Union and the ICAO Council, which is the Council on Aviation. And so it was a very interesting and exciting way to approach one dispute across multiple fora of international law. But I've also done a lot of investor state cases. I've done some commercial arbitration. I haven't had a chance to work on many cases in U.S. courts, but you know, life is long. I'm sure I will hopefully have the opportunity to do so in the future. To speak a little bit about pro bono work, I was, you know, recently actually speaking to one of your colleagues from Berkeley Law. We touched base. We had a virtual coffee Zoom, and she asked me a little bit about my pro bono work, and I've reflected a lot on the type of pro bono cases that I've taken, and not just that, but you know, this sort of my personal and professional desire to do pro bono, which has been a huge part of my professional career. And before I came to Foley, I did a lot of asylum cases, asylum work, and I really sought out pro bono as a way for me to sort of do the kind of work that I was really passionate about. You know, I was very intellectually interested in a lot of the cases that I was doing in my billable work. And then I often thought of my pro bono work as something where I could maybe, you know, work on human rights issues or asylum issues. Since coming to Foley and having now had the opportunity to work on some cases that have a human rights element to it, and one of my main clients at the moment is the Republic of Armenia. We represent Armenia in 2 cases before the International Court of Justice, but also cases before the ECHR. And those cases are very much driven by human rights concerns. We had a very, you know, sad case of ethnic cleansing, what we would consider to be ethnic cleansing, or we argue to be ethnic cleansing, but other sort of discrimination. And so it's very both professionally and personally fulfilling to have billable work that has such a, you know, unique and important human rights element. but at the same time, I'm grateful I have an opportunity to work on pro bono, many different types of topics that come up that I wouldn't maybe necessarily have had an opportunity to work on as billable matters. One of the big pro bono cases that we've taken a fully in the recent years has been to do with climate change litigation. We've represented a number of states pro bono in the advisory opinion before the ICJ, and provided them then thereafter sort of advice on implementing what we think are going to be obligations under international law to fight climate change. But we've done a lot of work on gender apartheid, amicus briefs in domestic cases that are related to restrictions on healthcare, for example, bringing an international law perspective to some of these restrictions. I guess to kind of, I've highlighted some of the cases I've worked on to sort of kind of conclude my very broad introduction to Foley and to my work. And again, I think someone mentioned in the beginning, this is not a very traditional career path. And I think that's what I loved most about it. And not just that I get to work on really unique, different, sort of cutting edge cases, but that a lot of my colleagues that I work with did not take necessarily a traditional way in law school to get to the career they have today. We have foreign trained attorneys who have come to the US for their LLM, but also attorneys who have had their JDs from US schools, and then have gone on to do a number of different things before finding their way to Foley. So it's a very unique, exciting, and wonderful community of people who are just really interested and passionate about international law. And I'd be happy to speak more about any of the above and anything else, but I've taken up a lot of time, so I'll cede it to my fellow panelists. Thanks.
Thank you. A very interesting and unique firm. And I'll just note that a Berkeley Law grad did some of the arguing in the advisory opinion case at the ICJ. So there's a path there.
Exactly.
And I believe she was Yulia's colleague, Christina Reyes, who graduated in 07.
That's right.
Yes, I work very closely with Christina. She was the reason why I think I was introduced to your wonderful colleagues. So yes, Christina is a proud Berkeley member and a wonderful member of our firm, the global chair of our firm. So she's a wonderful mentor to me.
All right, now we're going to skip back to the West Coast. John, let's hear what you do.
Sure. Neil, thank you everybody for having me today. It's great to be here, great turnout. So I'll start from how I got into this type of work, and then I'll tell you the type of work I've done over the past 10 years or so, and try to hit some of the other points. And Professor Popovich, if I miss any of the points you asked us to cover, please feel free to interject. I studied international issues during undergrad. I came to law school really interested in trying to continue to study international issues. I took courses in international law here at Berkeley Law. And in my second year of law school, I took a course on foreign investment law, which is basically investor-state dispute resolution 101. And by the second day of that class, I was convinced that was the type of work I wanted to do. It was a perfect mix of all the things I was interested in: geopolitics, economics, history. And so I was motivated to get into it. And fortunately for me, I looked at that time. I had already gotten an offer to be a summer associate at Arnold & Porter. And backing up during the summer associate interview process, I was really looking for law firms that had some sort of international presence, not necessarily investor state arbitration work, which I don't think I was really fully aware of at that time, but just international work. And I knew Arnold & Porter was one of those firms, which is one of the things that had attracted me to it. And so while I was sitting in this foreign investment law class, I checked to see, was Arnold & Porter doing any of that work? And sure enough, they were representing several states in investor state dispute resolution, investor state disputes. And from that time forward, I was extra motivated to get involved. And I recognize, however, though, that that being in San Francisco, which is where I had my offer for, wasn't necessarily the best way into that work. And in fact, I spoke with the professor of my foreign investment law class, and I asked him, how do you get into this type of work? And he said, you should work for a firm in New York or Washington, D.C. or London. And I said, no, thank you. I'm going to stay in California and take my chances. And that for personal reasons, I love Northern California and family and friends are here, and I didn't want to leave. And luckily for me, Arnold & Porter had work in this space, and they had a demand for junior associates interested in working in this space when I arrived. And they even had a handful of attorneys in San Francisco doing work in this space. So very quickly after I started at the firm in 2014, I was assigned to a case for the Republic of Korea. And now 11 years later, I'm still working on that case. So those cases, is an aside, that they do not go away. So remember that as you're starting on these cases, and you can really be captured. And so from starting on that case as basically a site checker, which was the only real substantive thing I knew how to do coming out of law school, I am now arguing elements of the case in front of the tribunal, or in this case, an annulment committee. So things can progress the way you want them to. Frankly, I took a shot in the dark. I wasn't positive I'd be able to do it. I just hoped for the best, and I was, I think, at the right place at the right time. But I think the lesson there is, if you are motivated to do it, just make it known. And so wherever you end up working, just make it known that that's the type of work you want to do, and try to find the people who are doing that work and do good work for them. Because if you do good work for them, they will come back to you, and it shouldn't matter very much what office you're in. Or what geographical location you're in. So to answer one of Professor Popovich's other questions about sort of how is our group structured, we are a very cross-office group like Foley. So we have attorneys who work in international arbitration, and I want to say 4 or 5 or 6 of our offices spread out through the United States, a big cohort in London, and a few attorneys in Shanghai as well. And I've had cases where we have people from Shanghai and California, DC and London all working on it. And so challenging those conference calls is very difficult. And sometimes you get the short end of the stick and have to take it at midnight. But that's okay. It's part of the cost of doing business, and it can be fun. So our group also does a mix of investor state arbitration work. We primarily represent sovereigns. We've done some claimant side work. We've represented investors, but for the most part, we represent sovereign states. We also do commercial arbitration work. And then in my own practice, I have, being in California, recognizing that the market for international arbitration work is not as robust as it is in places like New York and London and Washington, D.C., I have made a concerted effort to take on litigation matters from time to time. So that's something you should all think about as you are trying to enter into this space is, can you make a full career out of just international arbitration or international law work where you are and the firm you're at? And keep in mind, it may be useful to develop other skills outside of international law work. And for me, it has been very useful. I think I've developed, I'm probably the only person in the world who has developed a practice in both legal malpractice defense and international arbitration. Those are two not really easy to put together fields of practice, but I've made it work, and I've been able to stay busy and enjoy my work throughout that time. And so really, I would say that is something to keep in mind, particularly as you continue to go through your career and think about what different phases of life you are in. And so one thing I'll say is, right now I have 2 young kids. And so taking those midnight conference calls is less than ideal. And so now being able to focus a little bit more on my domestic litigation, legal malpractice defense work has been a great thing for me personally, because it allows me to have calls on California time. And so I think that is something you should all be thinking about as you progress. Think about what you want to do now, in the next 5 years, the next 10 years, the next 20 years, and you can probably make it all work and bring it all together. I'm sure I've missed some of your questions. I can come back, but I'm happy to let the other panelists speak for a bit.
Thank you, John. Very interesting. And actually, it's not such an unusual combination. I actually had a case where I represented a law firm in an international arbitration where the main issue was whether they had breached their ethical duties to their former client.
I want to hear about that. I'm gonna pick your brain about that.
All right, so next we're going to come back kind of on both sides of the coast because we get Tom, who is based on the East Coast, but was very nice to come and be with us today. So Tom Walsh, and he's also was my former student. So, but don't hold that against him.
It's been a while. Can everyone hear me? So thank you for inviting me to be here. Always a pleasure to be at Berkeley. I graduated in '06, which probably sounds like a very long time ago to you. Feels quite recent to me. But in any event, that means I have about 18 years of perspective on practice. And I now spend a lot of time interviewing students like you, so I can hopefully give you some reasonable tips. I'm going to start with my career path, and then I'm going to talk a little bit about my firm, and then I'm going to give you the advice. So stay around for the last few words. My career path, not traditional. I did not contemplate being a lawyer till I was about 25. I was living in South America, doing conservation work, grant writing for an NGO. And this was 2000, 2003. And for those of you who may have studied this historical period of time, there was a peso crisis in Argentina, and there was the beginning of kind of widespread investor-state arbitration in Latin America. There had been investor-state arbitration for several years, but there was a boom in investor-state arbitration, and it has not stopped. And it was front page news every day in the Quito newspapers that I read. It would be oil and gas, roses or bananas, another big export, investor-state arbitration. There was graffiti on the streets, all about Oxy Petroleum, which was the first investor to sue Ecuador. So I learned a lot about it, and it is actually what caused me to want to go to law school. And so I fortunately got into Berkeley, and when I got here, I started studying everything that had international in the name. Fortunately, I took some other classes as well, because it turns out you need those other classes. And so don't just take the international classes, but you should take them. Found that all very helpful. I also spent a semester at the State Department. That was obviously under a different administration and circumstances, but spent a semester at the State Department in the office that defends the United States when it gets sued. So at the time, this was NAFTA, no longer NAFTA, but at the time, this was NAFTA. And that is a place where arbitration lawyers go when they want to leave law firms, or sometimes where they go when they want to have fundamentally in-house experience at a sovereign and then go back to their law firms. I think you can still spend a semester as a Berkeley student externing. So if you want to, LSID is a great place. It's the legal department, full of a lot of great lawyers from that typically came from law firms that where they like frankly like all of ours, where they practiced arbitration. And then I graduated, and like you, spent a lot of time figuring out what in the world I wanted to do. I do not come from a family of lawyers, so law firms were a bunch of names of dead people. And the offices all look the same. They're a bunch of glass offices, very hard to tell apart. I relied heavily on my professors to tell me which ones actually do arbitration, because as you've probably noticed, law firm websites tell you that we all do everything wonderfully. There's some truth, some half truth. And so I found it hard to decipher which firms actually do arbitration. Interviewed at a few that do, and I've been practicing arbitration ever since. I love it, and I know plenty of people who do. I know plenty of people who don't. So I'm not here to suggest that it's the practice to end all practices. There are a lot of other great practices, but I enjoy my day job. And how did I get here 18 years later? By doing a variety of different things when I was at firms. And that is kind of bleeding into my advice for you and your career path. So I'm going to come back to that after I talk about my firm for a little bit. So fresh fields, what do? We do a lot of things in international arbitration, which is what I'm going to talk about. We have teams in most major financial centers. So what do I mean? New York, DC, London, Paris, Frankfurt, Madrid, Hong Kong, Singapore, Tokyo, all the major centers, numbers of partners worldwide, I think we're like 36. In the US, where I sit, we're 6 partners, 5 counsel, and about 35 associates who work full-time on arbitration. And then there's a large number of associates who work part-time in arbitration, do other forms of litigation, because arbitration is a subgroup of the litigation group. That is roughly how we're structured. In the US, we do, in the arbitration group, since we have a dedicated group, I'm going to talk about that. We spend about half our time doing investor state treaty arbitration, so claimants against sovereigns or defending sovereigns, and then commercial arbitration, so business to business disputes. I spend more time doing the business to business disputes, something I really enjoy, and I do a decent amount of time, maybe about a quarter of my time, on investor state, and then about 5 to 10% of my time on what I think you would think of as public international law, though it's largely pro bono. That is not true of all my colleagues. There are many of my colleagues who actually have paying clients that do public international law work. That involves a variety of different things, some of which you've heard about from other panelists, but in representing sovereigns in border disputes, representing the UN in disputes. For myself, the pro bono work that I mentioned, it largely consists of work before the Inter-American Court for Human Rights. I try to focus my pro bono work on representing women and children. To give you a sample of my cases, I have one case representing a group of about 90 women from Peru who were forcibly sterilized during the Shining Path era by the Fujimori administration. Those cases are still winding through the courts, and so we are supporting a group called the Center for Reproductive Rights, who are lead counsel on the matter. I tend to work with the Center for Reproductive Rights somewhat repeatedly, but that's one of the cases I have pending right now. And then there's a group called the Vance Center, which is another NGO. They're basically housed in the New York City bar, but they focus on human rights work. And I have another case before the Inter-American Court for Human Rights, representing former judges and prosecutors in Guatemala who prosecuted corruption cases, and as a result were driven out of the country. Those are some of my favorite pro bono matters at the moment, and then I have about a dozen asylum cases at any given time. There are no shortage of asylum cases, as any of you who have worked with CARC would know. So that's a glimpse of what I do and what my colleagues do. In terms of, I'm just going to tick through some of the topics that we've been given. In terms of highlights of some of my favorite cases, they include the first case where I was allowed to argue. I got lucky. I was a 4th-year associate, and I was given the opportunity to argue a case at the Peace Palace, where it was my job to explain to a set of arbitrators what carbon credits are. They were incredulous, but I think I convinced them that they are a valuable asset, and my client ultimately won. Another favorite case was the first case where I was lead counsel, which was a commercial arbitration involving light bulbs. Doesn't sound exciting, but it was great. And then another, which was mentioned earlier, which is a case where I represented Glencore against Bolivia, and it was a traditional expropriation case. And it's the largest award ever against Bolivia. Why did I love that case? Great client. First big case I did with Freshfields. Great colleagues. And one theme I think I found throughout my career, and I skipped the fact that I spent a year clerking between law school and law firms. And I clerked on the First Circuit, and I found that I actually can like things other than international arbitration and litigation. And that fundamentally, what I enjoy is working with smart people on challenging things. And fortunately, I find that in spades in arbitration, but I think you can find it most anywhere. So choose your barometers of what makes you happy. So in terms of advice on how to go about building your career if you do choose to pursue international arbitration, or frankly, anything else, be a good lawyer. You don't have to be the best arbitration lawyer, you just need to be a good lawyer. When I am staffing my matters, and one of the questions we had is, our first-year associates staffed on matters in our summers? Yes, we need you. Please, please, you can't run a case without a full team, and a full team means junior lawyers, mid-level lawyers, senior associates, partners, and then senior partners, more junior partners. You need a little bit of everyone. And so, yes, junior lawyers get involved. What distinguishes you as a junior lawyer? Knowing the facts, knowing the law, working hard, being reliable, being responsive. Those are, in my mind, the key barometers. And when partners talk about associates, when we do our reviews of them, that's what stands out. It's like, is this person a team player? If I am in a pinch, can I rely on them? If I'm at a hearing doing a cross-examination, are they going to be sitting next to me and know all the facts? That's the person I want, right? What does that mean? That means raising your hand for work. That means doing a variety of work, whatever the firm has at the moment, because you won't always have the thing that you exactly want. First case I was ever staffed on was a securities fraud case. I was so unhappy. I was belligerent. I was like, I don't want to do this. I'm going to quit. And then I spent 30 days in Birmingham at depositions, and I learned a ton. And it frankly, it helped me out quite a bit in my development as a lawyer. So you'll be open to the work that's available to you and do it well. That is not to mean you should not try to educate yourself in international arbitration. Jump at the opportunities that you get. Jump at the opportunities to be involved in pro bono work where you can further your skills, professional organizations where you can learn about the community, learn about the issues that the community is facing. Talked to a few of you before the event started, and you talked about going to California Arbitration Week and things like that. Bravo. Keep doing it. There's also a journal in the law library, at least there used to be. It's yellow. It's called Arbitration International. Sign up for a class where you have to write a paper and just read that journal like crazy. You'll learn a lot. Maybe that's just what I did. Then, I think this is an important point, and going back to the being open to different types of work. Don't turn up your nose at work that is not international. You'll get a really bad reputation. You can secretly feel that all you want to do is arbitration, but don't tell everyone. At least don't tell anyone other than the arbitration people. You want to be seen as a team player, right? I'm going to pause. I've been talking a lot. But those are my nuggets for now.
Thank you. That's good stuff. One thing I just want to emphasize before we move to the next panelist is the resources that are here at this law school. It's not just the journals, but it's the faculty, your classmates who have a range of experiences, and the fact that we have somebody like Joan Donahue here right now, who was president of the International Court of Justice, and before that, she worked in the legal advisor's office at the State Department. This is an incredible opportunity to meet and learn from and talk to somebody like that. And if you just look around in this very room right here, there's a lot of rich experiences that you could learn from. All right, now let's get back to the Zoom portion of our program, and let's hear from Tyler.
Hi, everyone. Thanks for having me. Thanks for moderating, Neil. And thanks for letting an East Coaster zoom into the California panel. I'll talk a little bit about my path to becoming an international arbitration associate, and then I'll talk a little bit about how my practice at Covington has been for me. I think that Tom made a really good point about staying open to other work once you're at a firm. I feel like that just as much applies when you're in law school, staying open to a variety of courses and a variety of experiences. My path worked out for me very well, and I found a job that I love and a field that I love. And I know that the reason why I got there is because I was very open to new opportunities. When I joined law school, I didn't know anything about international law. When I was an undergraduate, my history of political thought class had us read Hugo Grotius for 1 week. And that was the extent of my experience with international law. And if you had asked me based on my experience reading Hugo Grotius, whether that was something I wanted to do for the rest of my life, I probably would have said no. But I took a 1L elective with the professor who at the panel discussing 1L electives seemed the most passionate about his course content, and things snowballed from there. I got involved with journals, I got involved with extracurricular groups, and ultimately, when I was a summer associate at Covington, I had a stated interest in international arbitration. I had taken several courses in what is a specialist field that really does set you apart if people have matters where they don't have to spend a lot of time explaining the basic principles of the field just to get you to be able to do some research. So I really think law school is a great way for you to get into the field, but I also think that making sure that you're not foreclosing other opportunities at the same time is just as important, and that you make sure that you get a large breadth of course content if you're an LLM during your 1 year, and if you're a JD during your 3 years at law school. Moving a bit to my practice at Covington and practicing at Covington in general. So our group is what I would call an international disputes group. Unlike Yulia's firm, I don't think that we are so specialized, at least at the associate level, across commercial arbitration, investor state arbitration, and PIL. I think most at the associate level will have an international or would be in the international dispute group, and then might have a minor in another group. For example, I do about 30% of the work I do would be commercial litigation in US courts. A lot of my colleagues in DC split their time between international disputes and international trade. Then other associates in New York will spend some time also in commercial disputes and white collar work. But for those of us who are splitting that with arbitration, I would say it's usually a 70-30 split with the minor. Covington allows us to do that. When we join, at least in the New York office, I'm formally a generalist litigator, and I have been since I joined. Now, my specialty in international arbitration is carried into more and more work, and that's what dominates my practice. But there's not a formal divide between our practice groups like that. And it's easy for anyone to express interest, especially as you're a junior associate, express interest for matters within the international arbitration group, and to get exposure and to get experience with it. In terms of structure for our firm, we're a relatively centralized firm with our international arbitration practice group being spread across offices and working across offices. Last month, I spent about 12 days in the London office with for a commercial arbitration that I've been on for a few years. And that was before heading with the rest of the team to a hearing in Brussels for that same arbitration. There was really no real divide besides the time zones between me being a New York associate. There had been another DC associate on the matter, and a handful of associates and partners based in London. And the cross office divide is just, I feel, invisible across our arbitration group. I've personally worked with partners who are based in, and the matters based in DC, New York, where I am, of course, London, Seoul, and Dubai as well. And I've felt that it's really just one group entirely. In terms of our clientele, I've personally been more on the claimant side than the respondent side, even in my one representation of a state in an UNCLOS dispute that was on the claimant side as well. Though as a practice group, we represent parties both on the claimant side and the respondent side. I prefer the claimant side so far, but we can talk to my other colleagues if you want to hear why the respondent side would be fun too. I think that maybe the last thing I want to talk about is pro bono work. And I think, John made a really good point on making sure that you remain a well-rounded lawyer. And part of that for me as an American lawyer with a JD is to continue to be a lawyer in American courts and not just in international tribunals or in arbitral tribunals. One way that I've done that is through my commercial litigation work, but another way has been through my pro bono work. I've represented in more than one matter. These are matters arising under the Hague Convention on Child Abduction. I've represented them pro bono, and the structure of that convention is to determine the jurisdiction that will decide custody disputes when the custody dispute is across borders. The convention has been weaponized in some ways to prevent women who are fleeing their spouses from being able to settle in the country of their choosing, and as a way to bring them back to the country where they fled from by using the child custody process. And I've found that it's been an incredibly fulfilling experience to be able to represent mothers in those cases. And in terms of my professional development, I feel like, litigating a treaty case in US court is really a dream for the kind of people who are interested in international law. And to be able to be doing that for what I've found to be such worthy causes has been very fulfilling. And it is an area where plenty of hands are needed. And I think that if as a law school student or as a junior associate, you were to find people who are working on those kinds of matters, I'm sure there would be a role for you to help out. And I think, Neil, that I've touched on the majority of the points, but there might be some time left if you wanted to come back to me or to the other panelists with more.
Okay, well, that's great. Thank you, Tyler. A couple of quick comments before we move to Katie. One is one of the things that has had a profound impact on international arbitration practice in recent years is Zoom. And there's kind of pre-COVID and post-COVID and the way international practice works. It used to be all about travel. Now it's all about time zones. And when you've heard a few comments about getting the short end of the stick on scheduling, but it is something that has changed kind of the practical reality of having an international practice. And that's something to consider. I also just want to touch on one point about pro bono, particularly because of kind of what's going on with law firms in the United States right now. Pro bono, one of the great attractions of pro bono, aside from the fact that it is a hugely valuable service that we are uniquely qualified to provide, is that in a commercial law firm, it is, at least traditionally, the only thing where you get to pick your clients and your causes and your issues. And to me, it's really important to protect that. So I don't want to veer too far in that direction, but I just felt it was important to say. Katie, let's hear about your practice and how you got there and all that.
Thank you. Yeah, so I am not a Berkeley Law graduate, but I am a Berkeley undergrad. So when I was here, I did legal studies and peace and conflict studies. And in spite of taking legal studies as one of my majors, I was adamant that I didn't want to become a lawyer. And so I did both the LSAT and the GRE when I graduated. And was like, I'm going to go to law school, but I'm going to get an MA in international arbitration, and I'm going to go work for the State Department or something like that. But part of that was I just wanted to end up in DC. Honestly, I was a West Coast kid. I really wanted to be on the East Coast. I love DC. And so I was just kind of looking for an excuse to get there. So I applied to, I think, all of the law schools in DC, and ended up getting into Georgetown, which was amazing, and went there. Now, they didn't have a joint program. George Washington did. So I chose rankings over the program, which, pros and cons over everything. Went to Georgetown and was like, I'll get my MA afterwards. I'll go and I'll get a master's after, which don't postpone that because you're not going to want to go back to school. And so I went to Georgetown and I was like, I'm going to do State Department, or I'm going to go work for the UN, or I'm going to do something public and, international law related, because I didn't really know what that meant. My dad was a lawyer, but he was like a small town civil lawyer. He had his own practice. I didn't know big law firms existed, honestly. And I certainly didn't know that there were like international practices. So I got it to Georgetown. And our second semester of 1L year, they had this thing called a week 1 program, which was basically they brought all of the 1Ls back a week earlier than everyone else from Christmas or your winter holidays. And you had 2 options. It was kind of like a mini elective. You had 2 options of what you wanted to do. And one of them, I don't remember what the other one was, but one of them was an international IP French law arbitration. These are all words I didn't know what they meant, really. I was like, how, what? So it took the 1 week course, and it was incredible. I was like, this is amazing. I get to learn French law, which, like, when else would I get to learn that or use that? It's IP, which I still don't fully understand. And it's this thing called international arbitration, where you kind of get to be like a generalist. It's similar to litigation, which I had seen. It felt like litigation-ish, but like different. And it was just so interesting. I loved it. So I just started kind of learning everything I could about international arbitration without being able to take courses in it, because I was still a 1L and I was choosing my 2L courses. So I was like, there is an option to take a class with an adjunct. And so I did. And we had this incredible international arbitration LLM program at Georgetown, and they put on all kinds of talks. They brought in speakers just like this. And so I was able to kind of learn about it and learn some buzzwords, but I still wasn't sure that's what I wanted to do, to go into kind of like a practice and private practice realm. So I did my 1L summer at the South African Human Rights Commission. And then I came back earlier than I expected, just to do like 10 interviews at EIR or OCW, on-campus interviews, whatever it is, OCI. And I chose firms that had these international arbitration practices, at least ostensibly, on their websites. And I made the mistake of not talking to professors about it to like see who actually had them. So I'd say about 5 of them were complete busts, like the most uncomfortable interviews, because I was like, I want to do cross-border litigation, international arbitration. And they're like, great, I think we do that. And like couldn't speak about it at all. No ability to talk about it. I was like, cool. But then 5 of them were really great. And one of them was an interview with the international arbitration partner in DC, like the head of that group in DC. And he was like, great, I want an associate. So got hired into that program as a summer associate, and it kind of just snowballed from there. And I think similar to John, I have 2 cases from when I was a summer associate that I still have, still ongoing. So they last a while. And so that was kind of my practice. I started working in DC in the International Arbitration Group. And I'll talk a little bit about what that practice looks like. But then I'm originally from California. My family's all here. I took the California bar out of law school, and I kind of was like around 2019. So pre-COVID, I was like, I think I'm ready to move back. I feel established in my practice. I'm about 4 or 5 years in. People trust me. And I think I can make this work. So I pitched it. And then COVID hit, and I was like, I'm going to do it anyway. And so I moved in May 2020 back to SF, and have been working here ever since in the International Arbitration Group, but as the only practitioner on the West Coast. And I'm a senior associate. There's no partner out here. And so I had to kind of pitch that to my firm. I had to be like, here is my business case. And so my business case was, we don't really have a disputes lawyer in SF. We had like 1 or 2 people, but I was like, I can be your local SF counsel. I can do litigation, and I'll talk about that. But when I came in, I was hired to do litigation and arbitration. I had done multiple jury trials. I've done more jury trials than most of the commercial litigation associates in my firm. I was like, I can do that. And I can grow international arbitration practice in California. You got to be a gunner a little bit when you're in a big law firm. I was like, I can do it, I promise. And so I moved out here, and it's been great. It has been a transition. I think, again, to what John was saying about practicing on the West Coast, you got to do litigation. It's kind of going to be hard to have a pure international arbitration practice here. And it's really good to be flexible with that, and to be able to have those skills. And so tell you a little bit about Norton Rose. So Norton Rose Fulbright is very small in California, not super well known here, pretty big in Texas, well known there. And then I think we're like the second or third largest law firm in the world. So you go anywhere outside of the US, like we're pretty well known. We have tons of offices in South Africa, Australia, Europe, Middle East, Asia, Canada, and then we have 10 or 12 offices in the US. So we have a lot of offices here. San Francisco is, I think, other than Denver, our smallest office. So we don't have a big presence. And our international arbitration group in the US is smaller. So we have 4 partners. They're in Houston and DC. And but we have a massive global international arbitration group, and we have big global calls monthly. To the time zone point, we now have them 2 times a month at different times, which is great because mine were always at 4 a.m., which it was really not enjoyable for me. Now they're like at 7 a.m., which is perfect. And so we really work. I don't work with anyone in SF. I only work with people in other US offices and globally. And my practice, like I said, is about 50-50 litigation and international arbitration. Norton Rose Fulbright, mostly I would say it does, at least my practice is more commercial than investor state. I do investor state, and we do both sides of, we represent both states and investors. We do a lot of claimant work on the commercial international arbitration side. And then on the litigation side, I started in court in the enforcement areas. So enforcement and resisting enforcement. And then also 1782 discovery and aid of foreign arbitrations or foreign litigations. That was kind of where I started in court, where I got that experience. But then that snowballed into kind of just being in court generally. And so now I have a fairly robust commercial litigation practice that has absolutely nothing to do with international. It's just kind of domestic issues. My last state court case was in Monterey, and it was a cannabis case. I had to learn cannabis law in California, which, you know, it keeps it interesting. So it's really fun. I like it because it's broad. It's you get to do something different every day, and you constantly have to adapt and evolve to different rules, different laws. And it's great, but adaptability is key. So pro bono, and then I'll do a little bit of advice like Tom. So my 2 pieces of advice for law students that are interested in this is, for me, writing was the big one. When I was in law school, I focused almost extensively on becoming a good writer. I did a bunch of appellate stuff. My externship was at the DOJ in an appellate division at the ENRD, the Environmental and Natural Resources Division. I did like an appellate clinic. And I thought when I went into Norton Rose, we had to rank. So appellate was my number 2. So if I don't get international arbitration, maybe I'll get appellate. And then I've also done appellate pro bono stuff as well. So I just have tried to be a really, really good writer, which I think serves you well in international arbitration. You're going to be writing a lot of briefs and witness statements. And so being a good writer, a persuasive writer is really important. The other one is being a good empathetic person. A lot of times you're dealing with witnesses in international arbitration who are terrified, and even in court in the US, who are coming into the US court, who are terrified of being in US court because they've heard about it and it's scary. Or they think that they might have some personal liability of some kind. And so your witnesses are often scared. They don't know really what's going on. They don't know international arbitration. And so being able to kind of hold their hand through this process can be really important. And you very quickly become the go-to person for your client, the person they're going to call. The partner's going to run the case. They're not always going to call the partner. They're going to call kind of a junior associate who's writing all the witness statements, who's writing the brief, who's asking all the questions about the documents. You want to become that person because you become indispensable. And then on the pro bono side, I really don't do anything international pro bono. All of my pro bono is domestic focused. I do, well, I guess it's international, and then I do some immigration work. So asylum and U visa cases. I, at one point, really needed a break. So I took on some drafting of wills and estate documents for low-income seniors, which was great. And then appellate work. So writing amicus briefs and things like that.
Great stuff. Wow, this is quite a lot of different paths. I'm going to spend just about 3 minutes on my path because I think it might be even more convoluted than everyone else here. So I went to Berkeley Public Schools from kindergarten through law school. So I'm a Berkeley native. And I grew up around some lawyers, although none in my immediate family, although my grandfather, who I never knew, was a country lawyer in Buffalo, New York, doing estates and trusts. a lot of New York wills. But I went to law school thinking I wanted to do something for social justice and maybe something international. And I ended up working my first summer at a union side labor law firm, which was kind of where my instincts had led me, and then realized that although I supported what they did, I was not quite committed to that in the way that they needed. So my second summer, I did one on-campus interview and then decided I didn't like that at all. Sorry, it was with Covington. But it's okay. And instead I worked for a judge my second summer for California Supreme Court Justice, who actually just recently passed away, Joseph Roden. And so that meant I didn't have a job coming out of law school. But luckily at the last minute, the clerkship committee here contacted people who were on different law reviews and said, have you applied for your clerkship? And so I scrambled and applied for a clerkship and clerked for a federal judge for a year. Which was a fantastic experience. And from there got recruited to a litigation firm where I was doing interesting stuff. And I did get the lawyering skills at a small litigation firm that are sometimes take longer to get at a big firm. And then I realized after a few years that I wasn't really doing what I'd gone to law school for. So I quit. And then I did go back to school. So I did go back to school later and get a master's in international relations at the Fletcher School of Law and Diplomacy. Where at that point, I focused on international law. And by then I was married with children. And so it was a very different experience of school and I had perspective. And from there, I decided I was going to try and do something very international. And I went to work at a public interest firm doing international environmental law, which I did for several years until I couldn't support my family in the Bay Area on a public interest salary. And that, so 8 years out of law school, then I finally kind of switched to doing kind of trying to bring together all the different skills and interests I had. How could I do this and do something international in a private law firm? And that's when I started trying to do international arbitration. And that was now 20 years ago. So I've been doing it actually 25 years ago. I've been doing it a long time now. But there are a lot of different ways to get there and a lot of different skills and perspectives you learn along the way. What I want to switch to now, though, is a question for the rest of the panelists, which is some of kind of the soft things that attract you to it and that make you good at it, that sometimes people refer to as cultural fluency or sensitivity, and sometimes there's a language component. Sometimes a lot of it is just judgment. And how one of the things that attracts me to the international arbitration practice is that there are a lot of opportunities to use those skills, to be comfortable with and use to your advantage the ambiguity and the cultural sensitivity that sometimes don't matter in a domestic case, and how that's kind of influenced all of you in your practices in no particular order. So if somebody has a thought on that, chime in.
I will jump in. I do think this is similar to the empathy point, which I think is an important one. Understanding human beings. It's like the ultimate complexity in life, right? That's fundamentally what we do, right? We deal with our clients, whether they are companies or sovereigns or NGOs, pro bono clients, and then we try to convince people to see the world as our client needs them to see it and to decide for our client. And so that requires us to understand our client, communicate clearly with our client, and then communicate clearly with that decision maker, and also communicate clearly with our own internal teams, which, as we've discussed, could mean people from multiple offices around the world. And one of the great things about our practices is you deal with people all over the world in a variety of different backgrounds, or people from across the United States from a variety of different backgrounds, different legal systems, different language backgrounds, different cultural backgrounds. And how do you communicate clearly to them and help them see the world how you would like them to see it? And it is a lot of soft skills, a lot of talking to your colleagues who might be from that cultural background. You get a brief written by someone from a different background from yourself, and you say, what are they getting at here? Or what is really going to persuade this arbitrator? And you kind of canvass your colleagues who might know better than you or who have appeared before this person or have similar experiences. And it's a real puzzle of humanity, but I think a lot of fun. And being interested in people and the different ways that they come to the world and the problems you're presenting them to resolve is, I think, one of the highlights of our job. That probably isn't any insight. I'm rather just observing the problem. But
That's what makes it interesting, I think. Other thoughts on that? I have another question then, that's kind of at the opposite end of the spectrum. We're here, the panel here is about careers in international arbitration and litigation in the private sector. To have a career in international litigation or arbitration in the private sector means you have to think about, as Katie said, the business case. And so that raises a question that you don't necessarily think of when you first join a law firm, but you absolutely have to think of when you become a partner or when you want to become a partner. Where does the work come from? What is this business? You have a skill, but your skill is a business that you are selling your skill to somebody. How do you get people to buy that skill? And how do you kind of set yourself up for success in that sense of building your own brand and making yourself the go-to person or part of a team, go-to element of a team to develop an international arbitration practice?
I can go first on that one. So I think I mentioned this a little bit. The things that I think have been really successful for me are when people get written products from me, they know they're not going to have to do too much with it. We will have talked about it before, but it's going to be polished and it's going to be good. And like there may be stylistic changes and differences that we want to make, but it's not like we're going to have to really delve deep and rewrite anything. I think that that's a really useful skill. Also coming into a practice and kind of or a team and sort of knowing the basic lingo, I would say. International arbitration, that can be really hard because it's not something you're going to learn in law school. You might hear, you take a civil procedure class, you're not going to take a procedure class on international arbitration. So seeking out those opportunities just to kind of know things going in, I think will help you build your brand right away of just like, yes, I can hit the ground running. I know what this is. The other ones for me, like I said, that have been really helpful are, I think, being personable and empathetic. And so I see myself as a true team player in that way of like, I want this to be a team. I want us to be cohesive. Let's like talk about this. Let's figure out how we're going to divide things. If we're going to have something that's going to be due overnight, like who has things going on where like tonight is not a good night for them and someone else can step up and take it. I don't want to just like assign someone something when like their baby is sick. Like that's not fun for anyone. And so like, let's make this a team thing and we all have each other's back. Because being a big law attorney is hard and you're going to have really terrible deadlines and you're going to be working weekends and you're going to be working nights. But like, if everyone feels like everyone feels like everyone else is pulling their weight, it makes it a lot more enjoyable for everyone. And then there was one other thing. Oh, time management and case management. I think as you get more senior in being a lawyer, being super, super organized and being able to manage a case and manage deadlines and anticipate things that have to happen will make you stand out as a junior associate. So if like you have your own calendar of like, here's what I know is going to need to happen in this case, and you reach out to the partner and you say, hey, I know we're going to have this brief coming up. Do you want me to get started on an outline? Amazing. That is such a huge thing for you. So like try to anticipate and manage and from an early thing. And the answer might be, no, I've got that. Someone else is working on it. And that's totally fine. But it may at least makes them know that you are paying attention and you are invested in whatever is happening.
Yeah, can dovetail on that a little bit. I think everything Katie described is absolutely right in the way to stand out as an associate and to get more work internally. And I think those are the exact same skills too that you need when you're even more senior and at the counsel or partner level or senior associate level and trying to develop business or keep business and get new business from clients you already have. And that's being responsive, giving polished work product, anticipating needs, anticipating questions that they're going to have and delivering on those. And so it starts from very early on, just the skill set and the sort of mental process of being that person who's responsive and detail oriented. And I think being a team player is critical. I think one of the reasons I've stayed with my practice group and practiced with the firm for as long as I have is because of the people, as the subject matter and the people combined. So I think being surrounded by people who are team players who can be lighthearted, but also be very serious and get each other's backs and do good work and be responsive and accountable, I think is very, very important.
Any thoughts from the East Coast?
I guess I can just chime in very briefly to say that, I mean, everything that's been said is exactly right. You know, I think as coming from a practice group where our clients are exclusively sovereign states, it can be daunting sometimes to think of how to build a practice and how to get clients who are sovereign states, especially when you're a junior associate or a more junior associate. And so I think, you know, our advice and that advice that I've been given and the advice that I always give is that the only way to build a practice, both internally and externally, is to do exceptional work. And also to just be in touch with the community of other attorneys who, you know, end up working in the governments or in-house, and whatever that in-house means for states, but being, you know, mindful of the what's happening in the legal community, what topics are at the forefront of your work, and doing that kind of excellent work and forward thinking about what, you know, what skills you have and how those skills can respond to whatever it is that's happening, that's, you know, that states are engaged with, that your colleagues are engaged with, and continuing to just kind of have a finger on the pulse of the international community and making sure that you're kind of an integral part of it.
Thank you.
Mind if I speak
Please.
again? I don't want to talk too much, but
That's okay.
I have strong feelings about this one. And I also think it's a really interesting question. You know, one, I will talk a little bit about how you can develop your own brand. But I think the first step in doing that is attaching yourself to an employer that you want to be associated with, that you're happy to be associated with. And I think there are two parts to that. One, do they do the kind of work you want to do? And then do they have the environment you want to work in? I was joking earlier that it can be very hard to decipher whether firms have the work that you want to do, but it's not impossible, certainly. And there are several sources at your fingertips that you can use to decipher the differences between firms that do international arbitration. You can look at things called chambers and partners. You can Google them. It exists online. It also exists in hard copy, probably in your library. Global Arbitration Review. These groups, as a business, rank law firms. They are imprecise in what they do, but they do rank law firms. They tell you about their practices. And in looking at these rankings, you can decipher who is actually doing a lot of arbitration work. And it's a handful of firms. Our firms are among them. And so you can figure out where the work really is. And they'll give you profiles of the firms, and they'll tell you things like, well, they mostly, represent sovereigns, or they mostly represent investors, or they do mostly commercial work, or they do mostly IP arbitration work. And that's, I think, valuable intelligence that you can use to try to at least figure out, is it the kind of place that does what you want to do? Is it a place that I'm going to be proud of and like the people I'm going to work with? You got to go talk to people. That's very hard to figure out, the cultural fit. I think that's the hardest part, and just talk to as many people as you can.
Especially associates.
Yeah, especially associates. And then the building of your brand bit. Part of it is, of course, attaching yourself to the firm, and then within the firm, working your way up the ladder, like everyone's been saying. And I like to say, treat everyone like your client. Any more senior lawyer, you're a first year associate, treat the second year associate like your client. Be responsive to them. Try to understand what they need and give it to them. Same for a mid-level associate, senior associate, partner, and actual external clients. the name of the game is fundamentally being the kind of person that people want to work with and will come back to with work. And that's fundamentally what I'm trying to do is, have clients that I like come back to me with more work. That is a good day. And to have associates who I like working with want to continue to work with me. These are at a very high level my career goals. Like working with people, convince them to like to work with me. And it's very simplistic, but think about that. At the end of the day, if you're a junior lawyer, the lawyer just one rung up from you is in a way your client. And so treat them that way and they will give you good work. If you do good work for them, they would do well by you. And so that is, in a very simplistic way, a way to build your brand internally. Externally, you can start attending, conferences, arbitration conferences. Ideally, you're getting the blessing of your colleagues to do that. You can, in your copious free time, write journal articles or find out about client alerts that you can write, things that allow you to step outside of the firm name and put your name out there, in the community in which you choose to practice. And pro bono is another way to do that. But there's just a sea of international organizations that you can take part in and you can organize conferences for. I first started getting involved in a group called the Institute for Transnational Arbitration because there's a former professor, David Caron, who's now passed away, who was the chair of the group while I was a student. And I was given the glorious job of writing mock scripts for arbitrations. I spent unbelievable numbers of hours in the library writing these things. Knew nothing about arbitration. I don't know how I muddled through it. But it introduced me to a whole world of arbitration and allowed me to start to get to know people. It's how I met the then head of Freshfield's arbitration practice. It's just a good networking opportunity. So you have energy and enthusiasm, and although it doesn't feel like it, you have some time on your hands. And so you can try to put that to work.
I used to use the videos of the ITA mock arbitrations in arbitration class.
Yeah.
Got a little bit dated. The hairstyles started to look a little.
But the scripts were great, right?
Scripts were fantastic. Yes. I want to just make a quick point about the organizations. There are lots of international arbitration organizations. So as with the firms, do your diligence, dig in and see what they really do. They are, in general, fantastic opportunities to get to know like-minded people, helps you think about opportunities you wouldn't otherwise have thought of. And you learn stuff. They have great programming. But again, you got to look at what they're actually doing. Who's speaking? Is it somebody who you want to hear from? Are there people you want to get to know? It's also important to distinguish what it is you are trying to get out of these organizations. It's one thing to want to become part of the community, which is very important, and to learn some of the kind of the ways of the world of international arbitration. It's another thing if you're using that as a marketing opportunity to try and get clients, because then you don't want your audience to be all your competitors, right? So you need to kind of think about what it is you're doing when you are spending this time taken from your copious spare time because it does take, you get out of these organizations what you put into it. You can be a casual participant and you can have fun and learn stuff, or you can really get invested in something, put in a lot of work, make some great connections, get yourself on panels to present to clients and not just competitors, and use it, as part of your professional development. California Arbitration is good. Institute of Transnational Arbitration, ICA, the American Society of International Law. There's lots and lots of organizations, and there are country-specific ones depending on where you practice as well. What I'd like to do now is turn it over to the audience if we have any questions from the audience for any of our panelists. Yes, in the back.
Yeah, I do have one. Thank you for your advice and your experience. I wonder, because you emphasize on flexibility, what is your perspective in the future of international arbitration, especially investment? I read that Europe, there's a lot of pushback from Europe, also from Latin America. So I don't know how this is going to change. So obviously, from your perspective, I wonder.
Well, I'm assuming that you're referring in particular to the pushback against investor-state arbitration and the intra-EU cases, which are very specific thing, and for those of you who are not familiar with this, there was a landmark case that where the European Court of Justice held that a non-EU institution cannot decide EU law. They are the last word on EU law, and that kind of wreaked havoc on intra-EU bilateral investment treaties and other things that purport to decide issues of EU law. But I'll defer to those who do work representing sovereign states. I've been on both sides myself, claimant and respondent. And what do you think about the future? Tom, I know you do some of that kind of work.
Yeah. I love the question because it was something that we were talking about when I was a student as well. And in 2006, the year I graduated from Berkeley, they amended the ICSID rules. There was all this discussion of some of the Latin American states were starting to withdraw. Was this the end of investor state arbitration? And the states all signed back up to ICSID, and they signed on to the amendments, and they have not, for the most part, exited. There are changes. The US and Canada completely rewrote NAFTA, and now we have the USMCA, which has gutted the arbitration component and eliminated it in some cases. We have the intra-EU challenge to energy charter cases in particular. That said, the number of investor state cases is not diminishing. It just continues to keep increasing. And frankly, in the current environment that we're living in, where we have states taking actions against private companies based on the nation they're from, that's kind of quintessential discriminatory behavior, which I think will just lead to even more cases. So don't worry, you will have jobs.
A couple of comments that I would add. A lot of the treaties that contain investor state dispute resolution clauses have very long tails. They're either very difficult to get rid of, period, or they will have a sunset clause that says you can still bring disputes for a period of 5 or 10 years or something like that. And so it is entirely possible that even if states do start withdrawing from ICSID or from their bilateral investment treaties, there still will and be disputes coming down, for better or worse. I think, though, an overarching issue is that the ICSID system in particular, and investor state dispute settlement system generally, is really a product of post-World War II economic reform and the idea of strengthening the rule of law in favor of to attract foreign investment. And you've probably noticed there have been some sort of shifts away from the post-World War II in recent years. And so you may continue to see changes that have that dramatically alter how the system functions. So it may not look the same, in 10 years, but I'm sure it will be there in some form.
The only other piece I'll add to it is, again, that's just one part of international arbitration, the investor state part of it. There's obviously commercial as well. And then you can think too, like as you were just saying, things pivot all the time. So sanctions work is often a big part of kind of international practices. It's not necessarily straight international arbitration, but definitely an international component. And so there's lots of ways you can build a career in kind of international disputes work. And so you might have to kind of get creative with it, see where the work is. That's our point about being flexible when you're a junior associate. Where is the work at that moment? Kind of follow that. Maybe you'll develop a specialty you didn't know about and really end up liking.
There has been something of a backlash against investor state arbitration, no question about that. But that kind of leads to the question ultimately of what else is there if you're going to have foreign investment. And I heard from there's a Yale professor, Michael Reisman, who said basically if international arbitration didn't exist, somebody would invent it. So something like that is probably going to end up anyway, because the alternative of proceeding in the domestic courts of the host country where you have started your business is not going to be conducive to foreign investment. So there's going to be some shaking up of things, I think, but I don't think it's going away either.
Mm-hmm. Anecdotally, Argentina has been one of the most sued sovereigns, right, in the history of investor-state arbitration. And it rolled out in the last year an investment program that's intended to incentivize foreign companies to bring hard capital into the country. It's known by the acronym RIGI. It includes an arbitration provision. The government passed this legislation voluntarily putting this into the RIGI provisions, acknowledging the fact that if they are going to draw in trillions or at least tens of hundreds of billions of foreign investment, they need to allow foreign investors to bring claims in international arbitration rather than rely on the local courts. And so that's anecdotal, but an example of an important investment destination that is still turning to international arbitration.
Those are interesting cases too. I represented Argentina for a number of years. As a lawyer, not that your clients don't want their cases to be interesting necessarily, but as a lawyer,
Yeah.
they're very interesting case. Other questions from the audience? Must be things you want to know. Yes, please.
That we have a public international law practice, how the developments to the current administration and the reaction to the ICC, the sanctions of the ICC, the retaliatory response about the South African case, how is this impacting public international law?
Julia, you want to take a crack at that one?
I would love to, but unfortunately, I wasn't able to hear the question. So
Oh,
if you could
okay.
repeat
Can
it,
you
that would be
repeat it?
great.
Speak into the mic. Can you hear me
Yeah.
now?
And yes, with the mic would be better. Thank you.
Yeah. Yeah. So I was asking, how do you see the developments with the current US administration? How do you see that affecting public international law practice for the firms that do have a PIL practice, particularly developments with the sanctions on the ICC and the retaliatory response on the ICJ for the South Africa case?
Yeah, that's a very good and very hard question. And if I knew how this administration was going to impact the global order, I would be looking into the future. I think what we've seen in the last few years is an appetite for states to be litigating their disputes in international courts. We've seen a rise in cases before the ICJ, applications by different states before the ICC. And of course, the US is always going to be an maybe outsized player in world politics, and its sort of backlash against international law is going to be felt. And it's not the first time that, the administration has pushed against international legal norms. We saw a little bit of that, including sanctions on the ICC in 2016. I certainly don't think it's necessarily going to put a stop to states using legal fora to be, trying to settle their disputes. But I think it certainly will have an impact into, what kind of disputes we're going to see and how states are going to make use of some of these international organizations. I hope to see other states band together to protect the legal order. I think we see a little bit more of that coming from Europe now. But that's about as good of an answer I can give you as from where I'm standing right now. I still feel like I'm trying to come to grips with what's happening and trying to see how this is, how these changes, sort of whiplash of changes, is going to impact our work for our legal, for our sovereign clients on the international forum.
I think it swings in a lot of different directions. And the US is an outsized player, but sometimes it's an outside player as well. And there certainly have been situations where the US, by taking an extreme position, just kind of takes itself out of the conversation. And so there will be, and there's so many other countries and so many other issues in the world that although the US has an impact, there's still public international law is going to continue to be hugely important in governing and managing international relations. I don't think it's going away.
That's a great question for Joan Donahue.
Yes.
You should go to her office hours and then let us all know the answer.
Can you hear me?
There we go.
So I have a question related to careers in international arbitration, especially for LLM students. What can eliminate the bias in relation to LLM students in international arbitration practitioners willing to practice in the United States? And what can make them stand out? Their resumes or maybe their personalities in a lot of applications that you review.
That's a tough one. I have some thoughts, but I want to hear what everyone else has to say first.
I can make a couple comments. I know an official with a foreign government who I've worked with who did his LLM in the United States in New York and then worked for a time at a major international law firm practicing international law. So I asked him this question because I've heard it a lot. How did he go from an LLM program into an international arbitration practice in the United States? And he said the sort of determinative factor was that he wrote articles, or one or more articles, and I think began working with somebody at that law firm about it. But when he went to interview and having had written that article about an international arbitration topic, it was able to stand out and sort of prove that he was serious about this. And I'm sure the rest of his credentials were also superb. And all of you here doing an LLM at Berkeley Law, I assume and know that your credentials are all superb too. So those are some things you can do to stand out. Another thing that careers in private international law don't necessarily need to begin with a law firm. And I think you could also think about looking at opportunities to serve as a tribunal secretary, for example. ICSID hires foreign attorneys to work as tribunal secretaries. You can live in Washington, D.C., and then that can be a catalyst to then get into an international law firm setting. And there are other opportunities like that with other institutions as well.
I'm going to do a quick plug on the article writing side of things. So one way that you can start to publish articles now as a student is through Young Cal Arb. We have a partnership with Kluwer Arbitration Blog. And so if you reach out to me or the co-chair of Young Cal Arb and you are a member of Young Cal Arb, which I believe is free for law students. Yes, okay. It's free for law students. So join, reach out to my co-chair and I as members of Young Cal Arb and give us an article topic that you want to write, as long as it's about international arbitration. And then we will get that published in Kluwer Arbitration Blog. We'll work with you to help you edit it. And it's a really easy way. They're short articles. I think they're 1,500 words max. So just think about that.
And I'll say one more thing, and I'm sure Tom and Neil in particular have better insight into the hiring process than I do as partners. That some law firms offer foreign attorney programs. And so those are designed for LLMs who receive their law degree or qualification in a different country, but then typically completed an LLM in the United States. And so that it is certainly no guarantee as a path to then get a full associate role at the firm, but it can be a foot in the door. So that would be worth looking into.
It can be a foot in the door, but quickly in response to that, it's sometimes a conscious not foot in the door. So you need to check the program, because there are some programs for foreign lawyers that are specifically designed not to be used as a stepping stone. So just check the firm and make sure. A few other quick thoughts on this. There are one of the biggest fears of any big law firm hiring is that they will make an investment in somebody, and there are curves of when somebody becomes profitable and how likely they are to leave. And They don't want you to be there temporarily after they've invested hundreds of thousands of dollars in training you, and then you've learned all this stuff, or you got this credential of working at a US firm, and then you're gonna go to your home country. And so part of the challenge for LLM students, and it's an unfair challenge, but it is a challenge, is to demonstrate that you want to be here and that you have an anchor here. And sometimes that means an immigration status. Sometimes it means having some language skills. Sometimes it means having some other thing that anchors you. Sometimes it can just be you get admitted to the California bar, or the New York bar, something that demonstrates that. Sometimes you're married to an American. I'm not suggesting that that's how you should be designing your career. But if I look around my firm and many firms, the people who are doing international arbitration, they have something international about them. Either they've spent time overseas, or there's something that makes them think internationally. And one of the challenges to get a job at a law firm is to connect with somebody who appreciates that. And so that sometimes requires kind of a deep dive into people's web profiles. They went to school at a school, they spent time in a school in your home country, or there's some other commonality. There's also a little bit of a double-edged component to this, which is you have to decide if you want to work, for example, for a US law firm, do you want to be perceived as the country specialist for the country that you're from, or do you want to be a broad-based international disputes lawyer? And sometimes being perceived as the specialist helps you get in. Sometimes it's, no, we don't do enough work for that particular country to have somebody who's that specialist. So kind of the takeaway from all of that is to do your diligence to understand about the firms, to look for commonalities of people in firms, and to look at the kinds of cases they do. Is it something do they do a lot of work in a particular industry where your familiarity with the business culture will help you stand out? So you have to look for things beyond just the fact that you are an LLM student, and think of it as your job, if you're trying to convince a US firm to hire you, is to demonstrate to them that you really want to be here and you want to be part of a US practice. And I've seen some of my former students have joined a US firm starting in an overseas office with the idea that then the US firm doesn't have to go through the sponsorship for immigration yet. And then they've convinced the firm that they're a valuable asset, and then the firm is willing to do that. Or then they decide they'd actually rather work in London. So it doesn't matter, and they're happy anyway.
Yeah,
on that?
I echo everything that everyone said. And as you probably know, there are a handful of firms, typically with the largest arbitration practices in the US, that hire a certain number of LLMs every year. It's not a huge number. Freshfields, we hire about 3 each year. And that is because they largely go into the arbitration practice and don't work in the other practices. And so you need a sustained practice that does not need US qualified lawyers. Though, of course, as an LM, you can become US qualified. And actually, the Freshfields global head of arbitration sits in New York, and she is Argentine and was an LLM, and is now my boss, and she's delightful. And so she's a great success story, but it is a rigorous process that, for better or worse, is harder than the JD application process. I will say, when given the opportunity to work with LLMs, I am delighted, because typically that means you've practiced for a few years and then you went through a very challenging job process, and you were very smart and very hardworking. So I don't have a lot of encouraging things to say other than stick with it and seek out the firms that have LLM candidates as associates.
And just to kind of close the loop on that, anticipating the reasons why US law firms are resistant to hiring LLM students is important. And part of that is language, part of that is concerns about permanency, and the writing issue is also something. And so that's another reason to do writing, to demonstrate that you can write good writing, persuasive writing. In a lot of international arbitration is in English, and certainly if it's at a US firm, it's going to be in English. So you need to demonstrate that you have those skills. Yes. Where's the microphone? And that's, I think this might be our last question because we're coming to the end of our
Okay.
time here.
Me? Okay.
Yes.
First of all, thank you so much for all your time and this wonderful panel. Like, we all really appreciate it. It's been very insightful. I have two questions. First is with regards to whether certain firms are specialized in particular international arbitration areas, because we've been speaking to it kind of broadly. I'm a bit biased, like Freshfields, for example, is renowned for its Latin American group. So whether you found within your firms if that they've been focused on a particular region, for instance. And my second question is whether you found that it makes a difference where the firm is headed. So for instance, whether it's a Magic Circle firm or a US based firm, particularly in light of the recent executive order with regards to security clearance, whether, for instance, we will see, and I'm sure this is an early question, but whether clients might, for instance, prefer firms that are not US based, but might be Magic Circle. So yeah, those two questions. Thank you.
I want to start with one kind of characterization of law firm international arbitration practices. There are some firms, as you've heard today, that have a specialized practice where most of the people who do international arbitration mostly do international arbitration, and most of the people who don't do it at all or rarely do it. There are other firms where it is considered part of the litigation or disputes practice. And my firm is an example of that. We have lots and lots of lawyers who do international arbitration, hardly any who do mostly international arbitration. I'm one of very few at my firm that has a really focused practice on international disputes. So that's part of the answer to kind of whether they specialize is different firms do in different ways. There are some firms that have industry reputations. Oil and gas arbitration is something that a lot of firms may be good at. There are some, as you indicate, that have geographic specialization, whether it's regional or country specific. That kind of specialization is something that partly by looking at the kinds of things that Time was describing, you look at a profile of a firm. What are the kinds of cases they work on? And by looking at where they have offices, looking at what their lawyers are writing about. And some of that is very easy to find out because it's publicly available. Some of it's not, and you just need to talk to people to figure it out. On the kind of where is the firm based component, that, I mean, each firm is unique, but that can sometimes have a big influence on the culture of the firm and the way work is divided. And some firms, as you've heard, I think from most of the panelists, share work across offices broadly. Other firms don't. There are kind of silos. And so that's another thing you need to learn about. So I think that the kind of the broad answer to your question is every firm is different. And you're only going to learn about that by digging deep on the websites and talking to people and reading about what they actually do, not just what they say on the website that they do. Have other perspectives on this?
Yeah, I think looking at where they have offices, you can look at what languages the people in the US speak. I mean, a lot of times they'll put that on their profile, you know, what languages they speak, and that'll tell you a little bit about where they're working most, honestly. But I think looking at the reports is a really great idea, GAR and IAR, and seeing what cases they're actually reporting. Because a lot of that has to be confidential. So, you know, a lot of it you're not going to see, but especially on the investor state side, they can report a lot of what they're doing. So you can see what kind of where they have cases and what they're doing. For us, I think because we have so many international offices, a lot of our international, like you can head cases out of those offices in every region of the world. From the US, because we are traditionally, historically, a Texas-based firm. It's oil and gas and LATAM facing would be a lot of what we did historically. But once we merged with Norton Rose in 2013 or whenever it was before I joined the firm, became a truly global firm. So it just completely changed everything. But I think it's more to the culture point, honestly. Your head office, I think, affects your culture a lot. So New York, Houston for us, it kind of really dictates a lot of how we in the US specifically tend to function.
And there are some firms that get work because of where they are. There are some firms that get work because of a figurehead leading a practice. There are some firms that get work because they're just known as being really good at what they do. So it really is, it's very case specific. And ultimately, as Tom pointed out earlier, you got to think about what kind of a firm you want to work at. Who are the people you want to be around every day in your professional life, sharing ideas with, working on cases with, sometimes spending a lot of time with.
And there are a lot of commercial considerations about how law firms are run. They are fundamentally, they're partnerships, but they're businesses that affect associates, but for which I think associates generally don't receive much information when they're interviewing. One thing that actually really affects the culture of a firm is how the partners are compensated. Traditionally, there's been two models. There's been what's called lockstep and then eat what you kill. One sounds far more civilized than the other, obviously. But lockstep is simply that by seniority, you make more money. Kind of like each year, you theoretically add more value to the firm. You get compensated by the number of years you spend there, very roughly. Eat what you kill is you're compensated by the amount of work you bring in. This is all very simplistic. But that affects how partners interact and how you can be treated as an associate, whether everyone is kind of pushing for general firm success or whether people might be incentivized to focus on themselves or on their immediate groups. This can really affect your life. And it's not a simple clear-cut question of, well, which model do they follow? There are a lot of different models, and the firms are going through a lot of transition right now in the United States, and are switching models and doing hybrids. And so this is a level of sophistication that'll be very hard for you to chip through, but it is something that once you have a law firm offer, you can ask about. I wouldn't ask about it necessarily in the first interview. Maybe wait till you have the offer, then ask about it. It's also information you can get from NELP and places like that. But how people are compensated will affect you. And then firms focus on certain markets in part for business reasons. Like, are you going to a firm that presents itself as doing premium work for blue chip companies, and they're only in the most important financial cities or something like that? Or are they more of a firm that does volume work? They do all the work for a certain handful of clients in all these different jurisdictions. They're just different models. And when you hear us talking about, oh, I represent investors, oh, I represent states, and things like that, some of that is driven by conflicts and what we all charge our clients, because certain companies and sovereigns are willing to pay different amounts. And then there's the reality that if you work for a sovereign, there's some companies that will never hire you, and vice versa. And there's the reality that if you work for a sovereign, what other potential job opportunities are you creating for your colleagues? Maybe some debt issuance for capital markets work. If you work for a corporation, what other opportunities are you creating for your colleagues? And so while we're just talking about this in terms of arbitration and what I like to do, there are like nuts and bolts, dollars and cents reasons behind the way practices are structured.
I'd like to add a comment that it's not directly responsive to the question, but it relates to the idea of doing your research. It also relates to Neil's earlier question about cultural fluency. I think in that research that you do, make a concerted effort to know like how big is the international arbitration practice. It's one thing if they have a group, but like, is it a major part of the firm? Who are the people you're interviewing with? And you may not want to present yourself necessarily as somebody who's gung-ho, I'm only going to do international arbitration. That's all I want to do. I'm so excited for it. You might want to do that if that is truly how you feel. But if you're just trying to get a foot in the door, you should maybe temper the way you present that, because if you're interviewing with a transactional attorney or a litigation partner who doesn't touch international arbitration or doesn't know very much about what the firm does in that space, they might bristle at your enthusiasm for international law because they don't realize that the firm, they know the firm does that work, but they probably just don't fully understand how much it is. So this it goes to cultural fluency, knowing who you're talking to and maybe calibrating what you're trying to convey, just so you can get a foot in the door. And I think that was something I did because I was told when I was interviewing, international law is not a real thing. And so I was like, all right, well, I guess I'm not going to overplay how much I want to do international law. Turns out it is a thing, and you can do it and you can make your practice on it, but just be aware that not everybody realizes it's a thing.
it's a good thing, and seeing you all here today gives me great hope that a lot of smart, interesting people still want to do it, which is important because the problems aren't going away, the disputes aren't going away. And I've found it to be a really interesting, challenging, and rewarding practice area. And I think all of our panelists have as well. So I want to thank everyone for coming. Thank our panelists especially for taking the time, especially on the East Coast rather, where it's a little later. And I'm around the law school. So if you have questions, you want to come see me in my office hours. That's usually Wednesday mornings. I'm happy to talk to anybody about this. And again, I just want to thank all our panelists. Thank you all for coming.
Thanks to our moderator.
Thanks very much from the East Coast.
Thank you all very much.
Thank
Take
you.
care.
Bye.
No, I think that's important. I mean, it's a balance. I think